You're on the record.
Okay, I'd like to call this meeting of the Sunshine Ordinance Task Force Rules Committee of October 25th, 2016 at what time is it?
It's 4:34.
4:34 p.m. Mr. Clerk, would you please call the first item?
On the call of the roll,
First. Yeah.
Member Highland. Highland has informed us he is unable to attend. Member Fisher.
Present?
Fisher
Thing
present.
working? Okay.
And Chair Hinsey.
Present.
Hinsey present.
Mr. Clerk, would you please call item 1?
It's item number 2.
Two, sorry.
File number 16093, review and possible amendments to the Sunshine Ordinance Task Force bylaws and complaint procedures. Listed on the agenda is a list of issues that we could review today, but most pressing on this list is regarding the committee hearing process. The Compliance and Amendments Committee reviewed the complaint procedure at their last meeting. They provided a summary of their discussion in the packet. I believe it's on the first page of the packet. To summarize, there were...
This is not different at all from anything that we've already been doing for the last 2 years.
I believe there's a proposal of a change from what we're currently doing.
They're reinventing the wheel that you already invented, that what we're already using. It's already patented.
Yes.
We're already doing it. That there's
gonna be a
two
slight
pages
change.
of nothing. What is the slight change?
So the committees will be more of a pre-hearing process instead of recommending issues for the full task force to...
Okay, do we vote on that? Because I vote against it.
We can send that up to the full task force with your dissent on that. I believe the issue is that they want the committees to hear the matters and try to resolve the matters before they get to the full task force, and then the full task force would have a hearing on the complaints with the recommendations, and
Okay.
hopefully all the issues will be resolved by the time it gets to the full task force. But the full task force would conduct a full hearing. It would not be...
I disagree with that part.
It'd be
Yes.
a de novo hearing.
Yeah, I disagree with that part. I'm not totally against the resolving it before it gets there, but I mean, we've got 3 new people that think we haven't already spent 2 years on this. You, Victor, have put a lot of work into this. Fiona and I were on that committee, and let's let the system that we put in place that's working. If it ain't broke, don't fix it. So that's,
And I believe the other option that was suggested was to increase the number of
Expand
members
the membership, yeah.
of the
5.
complaint committee to 5 instead of 3.
So it's more people deciding the case, but it's not a quorum. So
Yes, I'm thinking about that.
I wouldn't, so no.
yes.
Yeah, I don't see that as being a logical idea. It's just going to tie up more people. I mean, Fiona and I have been on this complaint committee for about 2 years now,
Yeah.
and I thought it's nothing that we do here is perfect, but this has worked out pretty well. It's actually one of the few things that we have been able to do quite well. When we make a recommendation, it does reduce the amount of time in the full hearings. I applaud their effort here, but I don't see any reason to make any changes.
Yeah.
But thank you. Wherever you are.
Go on. I think that in terms of actually reducing the time of a hearing at the full task force, what we do is probably more efficacious for that purpose.
Yes.
I think that the specific case that Chair Wolf was referencing when he wanted to implement something like what we have proposed before us is, remember that case with the Department of Elections in which we had to walk through the whole thing about what a provisional ballot was? I think that
God, yeah.
the purpose of this would be so that the complaint committee would do that, and that we would that the full hearing would not have to walk through certain things, certain details like that.
I see what you're saying.
The way everyone, yeah.
Well, let's use the methodology that we currently have and let it do its purpose.
And here's the chair.
Are you on this committee?
I believe that he is sitting as a guest.
Right, but when I sat in as a guest, I always had to sit in the gallery, even when I was chair.
That's, chair's option. And
You mean it was my option then? You told me I had to sit there.
I'm not sure who the chair was at the time, but
Actually, I'm sorry, it was Andrea who told me I had to sit there. It wasn't you, come to think of it.
no, members of the committee can't sit on.
Okay. Okay, so
It's your privilege to sit at the dais.
next item. Or are we supposed to
No,
do
there's
Fiona
no
and I
vote.
do a motion?
I will
so-
note your
okay.
your ideas and
Okay.
write something up. The
Thanks.
next portion is the minimum requirements to process complaints.
Item
this
3.
is
Wait, where are we? Item 3?
actually this is still all part of item 2.
Sorry.
Second bullet
Bullet number,
is on the front. Second bullet.
augment the size, yeah.
This was a short discussion about what do I have to have in order to accept a complaint and to proceed to a hearing. If they don't give me enough information, should we delay the hearing until I can get that information? I will leave it at that and leave it to your discussion.
Am I reading the right thing? Where are we? Victor?
It's item number 2, the second bullet point, minimum requirements to process complaints. There's really nothing else in the packet regarding that. This is just
It's just the agenda.
a discussion item.
Oh, the agenda.
Yeah.
Minimum requirement to process complaint. Got it. Okay.
Yes, I currently have something a little bit written in the procedures, but it's a matter of enforcement. Am I allowed to not accept a complaint if they don't give me enough information? Do I hunt it down and delay the hearing until they give me that information?
What have you done up until the present?
Correct.
I accept all complaints no matter what.
Yeah, we've always leaned that way.
Yeah, we have.
But that does severely and negatively impact the commission, the committee, the meetings, everybody else that's waiting for their item to be called.
Yeah.
But on the other hand, I don't want to take anything away from the public. What do you think, Fiona?
Well, see, on the other hand, if Victor is now responsible for determining what the minimum standard is, then we get into this group of, well, what does the administrator then think is sufficient for processing a complaint? And I'm saying Victor could probably do a decent job of that. So then, do we need to have a standard then that?
A standard would be preferable so that
Yeah. So
it's not left to my discretion
So,
and
yeah,
I
we
can't
will-
be blamed.
Yeah, we want to take anything
Yeah, I
that's
agree.
away. We want to take anything that could be left up to Victor's discretion away. Not that we don't trust Victor's
I won't always be here.
Don't we already have a standard, or are we just kind of been loosey-goosey on it?
We don't have a written standard, but
Yeah.
if I don't have enough information to know what the complaint is, I
Yeah.
usually won't accept it
Yeah.
Okay.
until I can get more
Okay.
information.
I'd like to offer some input on this.
All right. Number.
So,
Yes,
so
Wolf.
yeah, one of the problems that we've experienced actually recently and in the past is not having a certain documents that are needed to actually be able to make a case. So, like, we don't have the original request that a complainant might make, a requester might make to a respondent. So then the context of the whole case becomes a little murky. And we're here sitting, having to figure it out what it is. Or if the complaint description is not, it's not very clear, it may be vague. So then we really need some kind of hard copy stuff to be able to kind of figure it all out. So it makes it easier, I think, not to waste committee's time, just process. That's all. It's not about judgment or being subjective or anything. It's just process, just to so that Victor can assign cases that seem like they have enough information for us to be able to do our job. And that's really what this is about, so that it doesn't become some arbitrary thing, so that, you know, members of the public are now pointing their fingers at our administrator versus him having a kind of
Yeah.
a
No, we don't
clear
want
set of guidelines. So I would rather, I think it's best that we have some sort of kind of parameters, you know, kind of
Yeah,
thing.
I'm down. I'm good with that.
Member Fisher and I agree with that. We just don't want any. We want minimal discretion on the part of Victor, so that we avoid the pointing of
Problems.
Yeah, we avoid the pointing of the fingers.
And if it comes to pass that Victor gets reassigned and a new person comes in, they can just, like, they have a set of instructions
They
on
can
have
how to do
templates,
it,
yeah.
kind of thing.
Because, yeah, that has happened. Okay,
Yeah.
so what do we do with this, Victor?
Yeah,
I can draft something that we can propose inserting into the complaint procedures.
Okay.
That would list what I believe might be
A minimum
a minimum
standard.
standard that you can
Okay.
consider and add to and subtract from.
Okay, that
Sounds
works.
good to me.
I will do so. Would you like to move on to the next bullet point?
Yes,
Sure.
the absence policy.
Absent policy. I believe that currently we don't have any provisions to excuse members from meetings. And as you know, if you miss 2 or more meetings at the full task force, it is still reported to the Board of Supervisors and so forth. I believe that there's a movement to insert excuse as a possible option.
But then doesn't that become subjective? I mean, I just ran here from the hospital. Would that have been excused?
Yes, that would be up to this task force to
Or the-
tell me how to
the
make that
chair, probably.
determination.
Yeah.
And would excused absence is not then be reported to the Board of Supervisors?
I mean, anybody, I think in the 5.5 years I've been on this, I think the only time I ever missed a meeting was, well, once I was out of town and once I had another event that I could not get out of. So, I mean, out of town, I'm out of town. Is that
It might
excused?
be a criteria of deciding what excused is as we possibly insert this as an option.
Yeah.
I mean, I was in Connecticut.
And then would those excused absences not be then reported to the Board of Supervisors? Or
I believe that an excuse would not count
Okay.
in this theory.
Right.
So basically, we're just putting it on people to be responsible enough to tell us that you're not going to be here. I mean, if you're a no-call, no-show, you deserve a dink,
Yeah, I
whatever
think
the
that's
expression
that's
is.
the that's the essence of it. I think that if like we're inserting this policy so that if someone has a work thing that they that they can't get out of. And,
Yeah.
Yeah.
And in terms of
Or a sick child. I mean,
Yeah.
the sick
Will we
child's
leave
a
it
tough one. I got to go
to the
pick up my kid.
discretion of the chair or
Discretion of the chair of the rules committee.
Yeah.
no, not the rules of the committee that they
Oh,
are
Of the committee that they're excused.
not present at.
I would.
Okay, so if they miss a EOTC, it's to the discretion of the EOT. Does this count for the subcommittees or just the full task
It only
force?
counts for the full task force,
Yeah,
but
that's
we
what I
would
thought.
carry that over to the subcommittees also.
Was a report to the Board of Supervisors?
Well, not for the reporting to the Board of Supervisors, but we would apply the same standard to the committees.
Really?
Okay.
I thought committees were a little looser.
We still need to either mark them absent or excused.
Okay.
And
I'm sorry, I think the issue may be, since committees are only 3 people, if you always end up with 2 people showing up, then kind of makes it a little
That
difficult.
happens a lot.
And then we have to find other then task force members to fill in to at least make it kind of full.
Kind of resemblance of a constituted committee. Yeah.
Yeah, but realistically, a lot of these subcommittee meetings are on Tuesdays, Wednesdays, in the middle of the day. And when I was commuting from San Ramon, there was just no way I could make it here. It's just,
Marin every
yeah.
day.
Yeah.
So is this something that you would like to suggest?
I'm okay. I agree with the full task force, excuse, unexcused, blah, blah, blah. And basically, it's just going to make everybody, check their calendars. check
their calendars.
Check their calendars and
Call
text
you
or
if they can,
email
yeah.
Victor. Well, I just text or email Victor.
Like, I guess there's kind of an unwritten rule of every task force member attending the full task force meeting and also participating in one committee. If
Right.
they start shirking their responsibility for the committee, then what, as far as attendance? And that's really, I think, kind of the crux for this discussion.
I think we're on 2 committees, which
Yeah.
is going
I
to
think I'm
not,
on
which
2
is going to
committees.
be a little difficult for me.
Except this committee doesn't meet that often.
Right, but it's
so-
meeting now, so I
Yeah.
had to.
Right.
yeah.
So is there a criteria for excuse? Are we going to leave it to the discretion of the chair, or this is only talking points that we would bring to the full task?
I would
Yeah.
I would leave it to the discretion of the chair.
I don't know. I think there's got to be some kind of standard or something.
Like
I mean, I
if
think
you-
what are we going to not, we're going to start being subjective, and then, someone's going to file, a harassment claim against Bruce. Well, he let this guy get away with it because he had to pick up his kid, but I was in the hospital and he said no. I mean, that puts Bruce, up
That was the
in a
exact
tough
same argument we had a
situation.
few years ago, and that's why we didn't
Yeah.
create an excused option.
Yeah, it's in the past, at least when I was in former years, people would be responsible enough to, like 5 days in advance or 2 days in advance, and then it was be excused. But if you have a task force meeting and they just don't show up,
Yeah.
didn't say anything, then it was like you were saying that they get that day.
We had one of those. He's no longer on the task force.
Still
Who just,
officially,
He still officially is.
not Rishi, the other guy who's not on anymore.
That was before my time.
No, it was just last year. Who just decided that he was too busy with other
yeah.
things and stopped showing up, and dutifully rolled himself off and did not reapply.
Got it.
But for the last 6 months, he's like,
Oh.
yeah, I'm not going to reapply. I'm not coming back. I'm done. I was like, okay, dude,
Foot out the door.
yeah.
Kind of
And
thing.
he just, did he ever call you to say he wasn't coming?
Usually he would.
Oh, did he? Okay. But he still didn't come,
Right. So, for the full task force, it's kind of clear, but for the subcommittees, is there a need, do you feel that there's a need to do this? Is there enough people that are like not showing up or not, on a regular basis kind of thing?
Well, we're missing one person today. Was
Yeah.
that told in advance? Is that considered
Yes.
excused? Okay.
That was told far in advance.
Okay.
Way in advance.
Yeah. I knew at the beginning of the month.
That's why I kind of appreciate Victor, kind of like, he has us almost scheduled all the way through the end of the year already. So
Yeah.
that way people can look at their schedules,
Right.
that kind of thing. So,
Or forget and then rush down here.
right.
Which
Right.
we have another thing today.
Yes.
So I believe it's an option that you want to implement, and at this time, I believe you're leaving it to the call of the chair, and that we're not making any changes. We're just bringing these talking points so that the full task force can
Right.
review it and make their own determination
Yeah.
which direction they want to go.
Okay.
Yeah.
Let's see what everybody else has to say. I mean, I'm torn. I think it either has to be there's no excused absences whatsoever, but then what happens? Or if you tell somebody, then you're excused. We're not gonna ask if you took your kid to school or you were in Connecticut or it was
I will so note.
Yeah, I mean, I think because then you're setting up
Then
a situation of potential favoritism or like, well, wait a minute, what? Because I had to go to the hospital to take, that's not excused, but this guy's had to pick up his kid and that is excused. I mean, that's.
And I think
I
we
just don't want to go down that. I don't want to go down that path.
I agree. I think you should just maybe leave it to the benefit of the doubt.
Yeah.
You know, that
Yeah.
people are telling the
If-
truth
if
and they're
they-
being honest
Yeah.
about it.
If
and-
they tell someone in advance,
Yeah.
then that's,
If you just no call, no show.
then you remember day.
Well, I always remember the actual meetings because they're always on the same Wednesday.
It has happened where some members have forgotten about the meeting.
Yeah,
And
that
I
was
call
me.
them during the meeting and then they remember. But
I did forget a meeting once, and thank God I was literally like 10 minutes away. I'm like, oh my God, I'm ready, I'm coming.
How about just maybe if a committee is experiencing a member that is
Yeah.
continually not showing up, that it just gets reported to me.
Yeah.
And then I'll have a sit down with that person and figure out what's going on. Is it something real that needs to be dealt with, or, is it, slacking?
Yeah.
And that way we can deal with, any kind of enforcement we think there should be.
What's my other committee? I don't even know.
EOTC.
Oh, and I'm sure you told me when that's meeting. I think that's the one I can't go to.
Starting to be
I think the next meeting of
40th.
EOTC will be in December 20th.
December?
Yes, I will review it.
December, okay.
December, yes.
Can you call me?
Next,
Can you call me the day or two before?
Yes. I will try to do
Can you
that.
call me?
Next on our list is the procedure for combining similar complaint files. I have one of these complaints.
Oh, that's never come up before.
I have one of them that is very definitely, in my opinion, only a complaint for the same IDR for the same document. I don't know if he accidentally filed twice or not, but I have stopped trying to make determinations like that, as they tend to get me into give me issues. I leave it to the full task or
Yeah,
to
but
the task force to decide
The
that.
problem with that is, so then you've got, I don't know, 6 complaints from the same person that are all interrelated, and then you put them all on the agenda, and then it knocks out other people's complaints for a month or 2 down the line, and it leads to an inefficiency of the committee's time.
It leads
Because
to a
then
backlog.
yeah, backlogs. So, I mean, if it's the same complaint against the same departments, or the same complaint with multiple departments, mush them all together. Because
Well-
it's not fair to,
We'll take public comment later.
there will be public comment, just not yet. Just not yet.
It's not yet.
I'm
No.
sorry, that's your call. You need to-
So I like to, I think maybe some kind of baseline that would be helpful. Like one baseline could be, and it could be multiple different baselines, because as you brought up, Lou, it's there could be multiple different scenarios. So one basic baseline is same complainant, same respondent on the same request, but multiple violations on the same request.
Do we ever get those, Victor? I mean, usually it's the same complaint, 6 different departments, and now it's 6 different
It can work
complaints.
both directions.
Yeah.
Yeah, I'm just saying that there's no hard and fast of how it is. I'm just laying out some scenarios so you can think about some baselines. Because then it's like you're still talking about the same subject matter. So if they, if it was an IDR, they didn't respond within 24 hours, and then when you finally make contact with them, they didn't respond within 10 days, and then they, it goes on and on like that. It's the same complaint, same respondent, on, same issue, the issue that was requested, but just multiple violations on the same thing. So that's kind of a basic, because you're dealing with singularities. On your scenario suggestion, you have same complainant, multiple respondents on the same exact issue, right? Those kinds of things. The complaint that the complainants have with that is they want their kind of full hearing time for each complaint, that they feel that due process needs to be for each individual complaint, because it's against different people, and there may be slight variations of violations for each one, even though it may be for asking for the same information, from 10 different departments.
Well, when I was chair, if there were multiple respondents, I said, okay, you get 15 minutes and bring all, so
Okay.
the complainant got, instead of just 5 minutes to state, they got the whole 15 minutes. And then each respondent was given 5 minutes. So it was like, okay, Arts Commission, Planning Commission, Election Commission, I'm making these up, but whatever.
Got it.
Boom, all came up and we merged everything.
Okay, that's it. I think that's a going in the right direction. I agree. I think that's a good suggestion for that. And I think members of the public would agree with something like that, and the complaint committee would try to help ferry that along. They could then kind of, at the beginning, determine whether these should be combined or not. You can have the parties there or not, and then, or at least send them a memo,
Well, if the complaint
communication.
committee hears that complaint, they don't hear all of them.
Right, they don't, but we're hoping that most of them do. I mean, Chair Tesfaye is interested in hearing, in at least reviewing all complaints, whether they come through her committee or not, just so that, the lawyerly mind can actually help us with some.
I don't think that's going to be feasible, though.
Well, that's her choice. That's what she's doing.
Well, she's not a dictator. We all get to vote on this. I mean,
No,
no one committee chair can make a determination that the rest of the committee doesn't have any insight into.
Well, her committee has discussed this procedure and how they want to operate.
Okay, they can discuss it, but we as an 11-person or whatever we are, 9-person committee still have the opportunity to weigh in on it. Is that correct? And we're the rules committee. We're the ones that make the rules.
Well, but I think the point here is that each committee can kind of more or less control how they want to run their meetings. And
That's fine.
If the complaint committee wants to take the extra time to hear complaints that are going straight to the task force so that they can actually maybe help the rest of the members get some, background or from a task force member perspective, what they think the background is, or some specific hard, things on it, or if they want to make a recommendation.
Okay, we're kind of going off topic
Yeah.
here, and
Okay.
I'm not going to agree
believe,
with any of that, but we'll deal with that when it
There's
comes
some
up.
dissent, and I believe it's been discussed, and the full task force can take it up.
Sure.
In part of this combining, I believe, my personal opinion, there needs to be some teeth behind it, in that the task force should be able to force the issue if they need to. They shouldn't allow this to be completely in the hands of the parties. And that's my only request regarding this matter. Would you like to move on to the next item?
No, I'd like
Yes.
to add, I think you brought up a point that needs to be discussed. My feeling is then I would say that, again, the complaint committee should try, figure all that out. If they can get agreement from both parties to do it, great, and then it moves to the full task force with that recommendation to combine the file. And if not, they could also make a recommendation without agreement, and have the task force agree, make that determination to do that at the time of jurisdiction.
Yes, and they can assign or recommend additional time at that time.
Right. Yeah, I mean, the point about assigning additional time is that should be kind of a hard and fast, specifics. So doesn't become arbitrary.
Set a standard for
Right.
additional time.
Right.
Yeah.
Okay.
Does that sound?
Well, we'll deal with it when it goes to the full committee. I mean, we're just hearing things now.
Yes, I will bring these issues up
Yeah.
in a report and so forth.
Well, I would hope that this committee would bring some recommendations in your wisdom to the full task force and what you think about it, so that there's some context.
Yeah, no, we discussed it
You
before you
did,
got
okay.
here. Yeah.
Cool.
Next on the list is precedence log. This is not necessarily part of our complaint procedures. This is just a wish list item that would assist the full task or any of the committees and the task force in making future or reviewing future complaints and trying to set a precedence regarding certain issues. We do not currently have a precedence log, and
Okay.
So that would be. That would be, so I can understand what this is. That would be when something comes up, we put it in the president's log and talk about how we dealt with it.
and then I would be able to make recommendations to parties
Based
based
on-
on past decisions of the task force of whether
Okay.
or not
Yeah, that's great.
their
That's-
complaint is likely to succeed or not.
Yeah.
I can give them a copy of previous decisions and so forth, but in the past, we have discussed creating a precedence log, and it did not meet, it did not go forward, as different versions of the task force have different opinions at times. They may not agree with previous task force decisions, so this is an issue that would need to be worked out on.
I don't see a downside to this. It's not
Yeah,
saying
I
that you
don't-
have to make your recommendations. Just this is this is history. I don't
Yeah.
have any problem with that.
It's like case law.
Yeah.
And I've
Exactly.
asked DCA Cola if he's found, kind of more recent, like in the past 3 or 5 years, orders of determination that speak to the same issue on the same kind of case. Kind of helps the task force say, okay, well, we should be somewhat consistent, and if there's some nuance that makes it not consistent, then at least it gives some
So
background.
you're
You get a head start.
Try to use previous OGs as kind of a precedence log, if you will,
Yeah.
which seems reasonable. And next iterations of the task force, that's not to say they can't change the precedence log to fit what they
Well,
agree with. So.
Well, you don't change the precedent. You just act
Adapt.
differently. You do something
Adapt.
different.
Yeah.
And now it becomes a new precedent.
I don't see a downside to
Good
creating
sample of this would be the matter where departments are automatically changing IDRs to regular public records requests.
Right.
I think it is precedence that the task force does not agree with that. And however, departments continue to do that. If we have a precedence log, we can distribute it and so
Right.
forth for
Okay.
issues of that
Because
nature.
at least we could say, well, we did it this way then, and it was, yeah.
I currently do it verbally.
Yeah, I do it because it's all in my head.
I tell them that's not going to work with the task force. They've previously stated that this is their position. This would give us something in writing. We could post it online so that it's not just my word. It is a task force approved document.
Right.
Is there any discussion on this? Or
Now we're good. We'll go to the next.
next is a big one for us, duplicated filing or re-adjudication of complaints. Part of this may be a statute of limitation. Well, actually, I list that later on my list. We currently have a rule in our procedures that in order to ask for reconsideration, they must make that request within 10 days of the order of determination being issued, and there must be new information presented.
So there has to be new info. Okay.
Yes. And the problem is evaluation of what is new information, who makes the determination as to whether or not this is a duplicate file or not.
Right.
And then there's also the problem in that if we do not make a decision regarding an item, there is no order of determination.
That's
so there's
right.
no possibility of, there's no written language regarding how to re-adjudicate an item where we make no findings.
Right, because they could be dismayed that there was no finding, no violation, and then they come back thinking I'm just going to get another swing at it. And it's like trying to get a second bite of the apple or something.
Yes. And there's a matter of who makes that determination.
Wow, I didn't realize what a slippery slope this was. Do we have this now? I mean,
It currently occurs, yes. I have previously, with the approval of the chair, prevented some of the refilings based on our procedures, but I believe some adjustment is needed to cover all circumstances.
yeah, I remember this when I was chair. There was somebody didn't get the violation, and they just refiled the whole thing all over again. I'm like, you can't do that. I mean, it's done. I remember that. We just didn't hear the case.
It's just a matter of who decides if it's a duplicate or not. And how do we make that determination? Is there a criteria? Or
Isn't it just decided on the facts? I mean, if it's the same complaint.
Same piece of paper.
Is there some baseline, is there some situation that anybody's experienced where there was a dispute that whether a case was duplicative or not?
I believe the Peter Warfield case is like that, where he stated it was not duplicative. And
The Mobile Code case.
Okay. Got it. All right. Well, I think it's helpful to have those heard at a complaint committee first to help make that determination, because then you have two levels of discussion. You have it at the complaint level, and then you have it at the task force level. And then you don't end up spending all of your time at the task force level having the argument and trying to figure out whether it's duplicative or not. At least most of that discussion can happen at the committee level.
Don't you cut it off before it even gets filed? I thought that's what it was.
I no longer attempt to do that due to
I had you do that.
without
Not a
it caused
guideline.
problems in that if they disagree with me, where do you go from there? It eventually I have to accept it. I accept all complaints. I don't have an option because I'm not a member of the task force. I'm not allowed to make official decisions.
Yeah.
Only the task force can make that official ruling.
Okay. So I think when I was chair of complaint committee, if it was duplicated, we just didn't hear it. We said, we've already heard this one.
Right,
do it that way?
and that's what I'm suggesting, that if the complaint committee makes that determination, then at least you have a set of appointed members making the decision, and not, Victor, being considered as subjective.
Right, because you could make the recommendation to the complaint committee that this could be a duplicate.
Yes.
Right.
Okay.
Yeah.
And there's the matter of how do I make that recommendation? If I do that officially and notify the people that I think is duplicative, they may take that the wrong way and think I am interfering.
It's just facts.
Yeah, well.
I mean, you process all of these. This is not subjective. This is factual.
Yes, and I could make my recommendation and let the task force decide, or the committee
Yes,
decide.
I mean,
Yeah, you can present your recommendation.
they're going to do what they want to do anyhow. So,
Are we ready to move to the next one? This one is a question. 5-day submission of documents in advance of a hearing. Currently, our procedures state that if we do not receive it 5 days before the meeting, the committee or the task force is not supposed to consider that document. However, that would prevent people from bringing items directly to the meeting, late items. Currently, the members have been reviewing items that have been received after that 5-day mark.
Yeah, in hard copy and hard.
So we either need to delete this rule or actually enforce it.
Yeah, this kind of goes back to the minimum requirements of processing a complaint, actually. I think they kind of are alike in a lot of ways. The 5-day submission of documents in advance of hearings is like the bare minimum kind of thing, but the minimum requirement to process a complaint is like which documents kind of thing. It's like if you file a complaint and you got no evidence of anything, that's the minimum requirement part. But you can then say, I'm waiting for some stuff to come, and I'll send it on to you. It's got to come before 5 days of the commencement of the meeting, something like that.
And will we, have a strict rule of enforcement?
Right. Right.
We would have to.
I've been party to many meetings where people will walk in with new evidence and expect the task force to be able to kind of your train of thought then it becomes so dislodged because now this piece of evidence may not have throws the whole case into a different perspective, and so it takes up. Everybody has to wait. They have to read it. They have to digest it on the spot. It takes a lot of extra time during a regular task force meeting. So, it concerns me. Everybody's got to kind of get on a schedule for making sure that the case is complete and ready to go. And if their information isn't available and they have new information, then it's time to ask for a continuance and say, I'd like this information to be included. So task force can't hear it on the spot. Sorry, we need just as much time as the rest of the public to be able to see things, new facts and evidence that come into play. So my suggestion is that maybe that then a continuance can be requested. And then if not, if it's denied and the complainant doesn't agree with the outcome, they can file for reconsideration. There's a process for that.
Okay.
That sounds
What
good.
do you think?
Yeah, that's Fiona.
That
Sounds
sounds
great.
good.
Next.
Actually, that goes back. I didn't complete the one regarding re-adjudication. Are we going to create a new adjust the rule to allow for or reconsideration of items with no decision
Well, here's my
if there is new information?
right. Okay, here's a problem. The task force should be making a motion on everything. There should be no case without a final motion on it. So it can't be like no motion on a case and it kind of like just dies there like that. There should be a motion to find no violation. Okay? Because then if the complainant says, I don't agree with that, they then at least have some due process for reconsideration if they can prove that and reconvince us. And if they can't, then the task force will again say, this will be, we still find in no violation and the case is now closed.
I agree completely. That is something I have wanted for many years, in that it gives us something to write down instead of just saying there was no motion and
Right.
therefore it was denied or
Right,
no
'cause-
violation was found.
Because then it kind of dissipates into thin air and then, the person's left hanging with nothing.
I agree with that one.
Right.
And in terms of, okay,
Yeah. Well,
and then in terms of the 5 days, how do you want to proceed with that? It would be, if they don't provide the documents within 5 days before
Victor,
the meeting?
I don't think that's, feasible. What if they have some new information a day or two before?
I just want to know how the task force wants to proceed.
Going back with precedent, we've allowed it the 5 years I've been on here. We can't just all of a sudden stop doing that.
Should we, this is just my personal thought, get rid of the 5-day issue and leave it up to the task force or the committee to continue matters if they believe they need additional time to review new documents that were received at the last minute?
Yeah, I think we're spending a lot of time on something that This is not a time to enforce it, and it's not a time to knock it down. Let's just have it be best effort, like it's always been. Unless that puts a major,
It's an absolute as written, and
But
we
it's
don't
never been
follow that up.
enforced.
We don't
yeah, but
enforce.
it's never been enforced.
Yes.
The only thing I would offer, and this is a question to you, is it easier for you to schedule, with regards to scheduling complaints, that when you have a complete package, that you can feel confident that, it could be kind of heard well by the task force, or at least the complaint committee, to actually start agendizing it, versus if there's some obvious documents, some real holes in it, like if DCA COLA says, there's not enough there for me to actually write up anything, and I don't want to make it up as I go along.
This would be a new concept for me to work out.
Okay.
In that, if we go with the initial discussion that I'm going to try to get everything up front before I schedule, versus, because I do have a cutoff. If I don't get it by that 5 days before, I do not put it in the packet.
Okay, that was my
because
question,
I need a
actually.
cutoff.
Okay, that was my question. So if we go with your suggestion of doing away with 5 days, then you're just saying you're putting it in the hands of the task force to make that determination whether to accept
Documents after my cutoff date.
documents after your cut, so you'll maintain the cutoff date.
You would still have the cutoff date, I guess.
Oh, okay.
Yes, just for packet
still have
material,
the
I need
cutoff
to have it by a date so that I can physically make photocopies, make a scan, and so forth. And I do notify all the parties that all documents must be provided by 5 p.m. on a certain day.
Okay.
Anything after that day, I don't even try to put it into the packet. I just bring it to the meeting and hand it out.
Okay, that sounds okay to me. Keep it kind of,
And then the stuff
Okay.
that comes after my cutoff date, it'll be up to you to decide if you need to review it or not.
okay. Yeah, I think that sounds fine.
He's the administrative cutoff date for
Right.
Next on the list, tabling for being unresponsive or non-apparent. My current practice, this shouldn't occur too often anymore, is to bring it to example, Charles Pitts. He's continued his complaints several times.
Okay.
And I have gone to the process of I will not schedule his item until he responds to me that he will actually appear. However, he hasn't responded to me over the last few months. So at this point in the past, I would usually schedule it before the full task force for a hearing to determine if they should table it or not for unresponsiveness. And the task force would usually table the matter as the complainant has been unresponsive to requests for scheduling.
You mean continue the item?
Actually kill them and table it.
Oh, kill it by tabling it.
Yes.
Okay. Well, so I think,
And then you would have to refile.
right, so I think what's might be helpful, have these cases, because we're trying to filter all cases to go through the complaint committee unless people request not to. But if they go to the complaint committee, they could help make that determination. I mean,
Yes.
if it's...
That may, if we adopt that process, that may alleviate this problem.
Right.
But it's just something I bring up, and that has been the past practice.
Yeah, you've mentioned that there was a couple other complainants that also will do that. They have, a slew of complaints, and then just before the like 2 or 3 days before the meeting, they withdraw them. Right?
That is a possibility, yes.
Okay.
This is probably a
Oh,
larger...
this is just for being unresponsive, just not showing up for a scheduled.
Yes.
Oh, I see.
Sometimes we'll schedule it before the full task force. They won't tell me anything.
Okay.
Nobody shows up from the complainant side. At that point, it has been policy for the task force to table the matter and give them the option of reopening it at a later time
Okay.
instead of continuing it without taking an action.
Has the task force in recent years taken on a case without the complainant present?
We have in the past.
No, they have,
Wait a minute, we've
I
done
believe-
another response.
Without the respondent?
we usually don't do it without permission or a request for us to do so. There have been requests that we do hear items without their presence, but if they
Oh, right, there was.
if they don't tell us anything and just don't show up, the task force has recently been
Usually
tabling the
tabling.
matters and killing them.
Okay.
We always do a quick, who's here, who's not here, and then we let the respondent go.
But the task force hasn't, if a respondent like continually doesn't show up, for a hearing, you don't,
We haven't tried to
There's
hear
been
it.
one
Really?
case in that where we have one person file at least 30, 40 complaints. He stated he refused to show up for hearing and so forth. So we scheduled them for review to determine if we should table them or not.
oh, okay. It's an interesting process. All right.
Yes, these are unusual cases with unusual people where we had to go create. We had to.
Yeah, you'll find precedent, though, in past years that the task force has moved forward with a case without one or the other parties present, depending upon how they feel about the case. If they feel that the violation was so obvious that they would sometimes move forward without a complainant, or that if the respondent refuses to show, that they would just go ahead.
It's a possibility, but I believe the cases where we have tabled them have been obviously needed to be tabled.
Okay. All right. It's an interesting process. All right.
But I believe we've gone with the standard of tabling if they do not show up without providing a response in advance of the meeting.
So has that been a written policy?
No, it has not
No.
been.
Okay. So it's been at the discretion of the chair of the
Yes.
task force? Okay.
We were trying to avoid continuing items
Right.
on multiple occasions and just having them sit there.
Yeah. Fair enough. I think it's a good middle ground.
And they can always ask us to reopen it. Therefore, I will tell them we table the matter. You can reopen it if you want. That would force them to contact me instead of just continuously continuing.
Okay.
Next on the list, maximum number of hearings per person per meeting. I don't know if you want to set a standard for this.
Yeah.
Well, the only thing because it's hard to tell. No, without if it depends upon who's waiting in line to be heard, kind of thing, and whether you have a number of cases with all the same respondent,
Yes.
so you want to make them all show up at one meeting, even though there could be multiple different complainants,
Yes.
That kind of thing,
Usually,
or
at
vice
this time,
versa.
we leave it to the call of the chair to deal with this issue.
Yeah.
The only thing I would want to avoid here is that if someone ends up monopolizing our agenda because Victor scheduled all their complaints and then something happens where they either don't show.
Right.
That would be my only objection or area of concern.
Yeah, that's a good thought.
Yeah.
Yeah, it's a good thought. So, I don't know. How would you think about mixing them up? I mean, would you?
I can
Do you
work
think
with
a
the chair.
variety? You think a variety is better versus having?
I think it's a case by case situation.
Okay. So,
I think usually at this time I work with the chair and try to avoid any situations where that
Okay.
might be a problem. And
how about this? How about a review of your recommendations to the chair of the task force, and then if there's agreement to that, whatever, or whatever outcome there is from that discussion, to then forward a memo for recommendation to the complaint committee, just giving them some kind of overview about what we're, just a recommendation
Yes, I
about
can do
these
that.
this particular kind of situation. So they know what's coming, and they could then kind of deliberate and
decide
discuss
what they
it.
should put
Yeah.
on.
And they can come up with, because they'll spend the time, and they'll be, the parties will be here, they'll have public comment, they'll get, enough input to help them make a decision. What do you think?
So you're suggesting review of Victor's agenda?
I
proposed
think I would
agenda?
make recommendations. I would review all pending complaints and make recommendations to the chair with and an explanation.
Okay,
Currently, I just set a draft based on my recommendations. I don't provide explanation.
Right.
okay, so you would provide the context, basically.
Right. I think it
That-
would.
That sounds good.
Yeah, it helps the task force members kind of have a little more control over, what gets heard at what time, kind of thing, versus, Victor putting it all, like 5 very highly complex cases all in one,
Meeting.
or it ends up being complex. You don't know, but it's
Yes, it's very rare that I can pinpoint how complex an item's going to be.
right.
Right.
Exactly. Just more eyes and more kind of discussion about it.
Next on the list is probably an important one for us, the statute of limitation for complaints.
Yeah.
I would
Yeah.
say maybe an IDR that's 2 years old. Should we be allowing complaints on IDRs that have occurred, may or may not have been responded to 2 years ago, as the people involved may or may not be around anymore? And this maybe not just regarding public records requests. It could be old documents that are online, minutes, and so forth. Should we establish a statute of limitation for filing complaints and statute of limitations for other issues besides filing?
Well, now I'm a little sorry. Now I'm a little torn on this one because that's why I said specifically like the statute of limitations on something that was filed 2 years ago, because I vividly remember a really poignant case that we had a couple years ago where a elderly gentleman wanted records from the coroner's, the medical examiner's office that were from the 80s or something, and he was entitled. Remember that, the old guy?
I believe
And he-
it's a different case in that they're filing a complaint for non-response to an IDR that occurred.
Okay,
over
if
a
you're
year
saying
ago.
filing a response to an IDR from over a year ago, I'm down with that.
Yes.
But you're not
and
putting a statute of limitations on,
that
I
would
want
be up
data
to
from
a department
1987.
to create their index of records. Certain documents are indefinite and
Right.
completely open. They're required to maintain certain documents indefinitely, and those will be
Like death.
always open
Yeah,
to request. But
Right.
certain documents have deletion dates or.
right. And he knew those documents were there and that it was going to be
I believe
a
that's a
Megillah to get them, but he, met with him and went through these dusty old boxes and made it happen. And I don't want to put a statute of
I
limitations
don't think
on
this
that.
would apply to
Okay.
that situation.
Just wanted to make sure.
Yeah, I think my concern about this is like some of what we've experienced here, where you've got lots of, for the new members, there are cases coming forward that they've never been party to
Yeah.
before, or they're so old. I mean, like if you go to court, sometimes there's statute of limitations. You can file a claim within 5 years of the
Right.
incident happening. I don't think that really
Okay.
applies to what we're trying to, what we
Okay.
do.
I got it. You clarified it. I
Yeah.
just wanted
Yeah.
to make sure. Okay.
So the question is what is an appropriate statute of limitation?
Right.
And I really would like to see it be more like 60 days, like 2 months from the time that the person feels that the violation is happening, kind of thing. So if something happened in January and then 2 months go by and, the 14 days have gone by, or every document got sent was unresponsive, and now it comes time, they're like, all right, I've had it, I'm filing a complaint, and they file a complaint, let's say in March, okay, that's fine, but don't wait until August to file a complaint for something that happened 6 months ago.
I think 60 days is too tight, but I'm willing to hear maybe. What do you think? I mean, if there, you know the bureaucracy. I mean, sometimes the bureaucracy gets in the way. So what do you think is viable here? Yeah.
And give everyone opportunity, 90 days to,
Yeah, I was going to recommend 90
okay.
days.
All right.
or 120, make it
Yeah,
4
I'm leaning
months.
towards 120 just because I know in my life stuff happens and I meant to do that and now a month has gone by and yeah. I'd say 90 or 120. Either one of
Yeah.
those I'd be fine with.
Yep. Yeah.
I'm willing to hear. What do you think?
Let's see. I'm easy on either 90 or 120. I would say 90 just because they might also remember
That's true.
the case better when they file it if it's.
And we can always put in,
I would think that for most of our people that wouldn't be an issue, but in the cases that maybe someone hasn't done this before,
Yeah.
and they're then we call them 6 months later for hearing, and and then they might have a little issue recalling what actually happened.
we may also want to put in a provision for waiving our own rule, in that there may be certain
idea.
circumstances where there is documents are being provided on a rolling basis, and
Right.
maybe 6 months later they says they're not rolling anymore. Let's file a complaint.
As long as there's an out in there or something, because what if documents get held up or something? That's fine.
Yeah, I think in your example, it doesn't matter for how long the issue has been happening between the parties.
From the
It's
last-
from the
last
point,
communication.
right? It's from the point of where it last happened.
Okay.
So if they stop the rolling let's say stop the rolling in March, and you want to give them 90 days, so April, May, June. You have those 3 months to file from the point of quote unquote violation that the complainant feels that the violation has occurred.
And I believe this may become an issue that the complaint committee will have to occasionally review, in which they don't agree with the rule and so forth, and
Right. So waiving the rule,
will
I think,
be
is
up to the
appropriate.
committee.
Right.
That's fine.
Yeah.
Yeah.
Okay.
Okay.
And they should state it. If they're going to waive the rule, they need to vote on waiving the rule.
Next on the list is the rule of reason. I believe that this has been invoked more often recently. I believe maybe the task force should create some criteria for invoking the rule of reason and proving that there's a need for the rule of reason, or something to that effect. In that, how do you prove that the rule of reason should apply in a certain situation?
Does everybody know what that is?
Yep.
Okay. That was the first time that I ever experienced the rule of reason being.
We've been dealing with it for 2 years
Have you?
now.
Okay. So
So
the question I have, I thought I had asked DCA Cola about it, was whether, because it's just case law, one case on this, or however many cases there are, whether it actually directly requires us to be obedient to it. That was my first question to him. And then when I thought about it a little bit more, I was like, okay, it doesn't matter if it exists or not. Whoever is invoking the rule of reason has to prove it. So in our last meeting, we had the case of Supervisor Preskin, where they were claiming that invoking the rule of reason because to retrieve 20,000 emails and try to print them out would have stopped their office operations cold. Well, first prove that there was that it was going to be 20,000. and then we can determine whether it was reasonable or not. Because the rule of reason doesn't specify whether it's 5,000, 10,000, 20,000, 200, 10, doesn't specify what would be unreasonable at that point. So I think it's important, if you're going to invoke something like that, you got to prove it.
Yeah.
You got to show some evidence that this will definitely, cause problems.
Yeah, well, definitely, I think that the burden of proof, so to speak, is on whoever's is on the respondent to say why they're invoking the rule.
And we can set certain things that we want them to tell us in proving it. So like the amount of hours or how many hours they're going to put into it every month, or the amount of hours it would take them to retrieve all the documents, and not just a statement of it's going to take us 50 hours. Tell us why it's going to take 50 hours.
Right.
This is just from previous experience on this.
Right. I mean, if they're going to claim whatever they're claiming is to be outrageous, they have to prove it. Essentially, if this is going to take us 50 hours to do. Well, okay, show us
Why it's going to take 50
why it's going to take 50 hours. Or there's 20,000 emails we'll have to print out. Well, show us a list of 20,000. Just show us the list. You don't have to print them all out. Just the listing, so we know that this is how many you've searched
And then
for.
I don't think they have the list. I think that in and of itself comes under a rule of reason. Well, we have to go through 20,000 emails to see if it matches this and redact information and all that, but at least show some proof. Write something up for us and tell us what you're going to do and estimate the number of hours or something.
And I think in the past we have said, in terms of emails, we said do a week's worth and tell us how long it took you to do a week's worth.
Okay, that's a good way to go about it.
And if they say that takes, fine, do a day, multiply by 7.
Or something to that effect of proof and not estimation.
Yeah.
And this is a new issue for the task force that has been coming up a lot more lately with large requests for documents and so forth. And it becomes an issue in, they invoke the rule of reason, but how long do it could take them months or years to finally respond to an entirety of one request.
Right. Yeah. So the rule of reason is just it's an invocation of something. That's all it is. It's just a function. It's not because you invoke the rule of reason that automatically they get a pass.
No, we still voted violation on both of them.
Yeah.
Even though one of the respondents was at least making an effort and said we're going to do it on a rolling basis. The other one said basically we're not doing it. Bye.
Right.
And that's why I voted violation for the second one.
Right. So
This will take some work for us to create our own policy regarding this, and it'll take us several drafts, I believe.
okay.
Next, vexatious complainants respondents. This is an issue that I brought up several months ago, but the testimony regarding this issue was not favorable, so we kind of put it to the side.
Can
It was a
somebody
matter of
give me?
determination of what is vexatious or not.
Well, can you give me some background on? I'm not following what the subject is here.
There was, in terms of respondents, we have certain vexatious respondents, such as the city attorney, who refuses to attend any meetings unless it's related to public records.
Right.
In terms of complainants, we have one complainant who filed 50 complaints against various departments in the city. And it was felt by many departments that it was a means of overburdening them.
So I'm having a little bit of a hard time with this one because the question is it really our burden to deal with this, or whether is it the respondent, quote unquote, the city's responsibility to deal with it?
They requested advice from us, and we have not been able to give them an answer.
Oh, okay. I need to sleep on it.
Okay. It's a difficult question. We started on it and we've put it to bed a few times.
Yeah, okay. I you know what? I think it's worthwhile to continue to have the discussion. I mean, and not make a quick decision about this, but there has to be some regular active discussion about it. Like it needs to be on somebody's agenda and with the ability to, you know, include public comment on it, have other task force members input on it. Because sometimes you'll go to sleep, you wake up, and you have a brainstorm, you know, and
You just need a reminder.
You just need kind of, I just think it's important to have this as an ongoing discussion. What do you think?
For the vexatious, I'm not ready to give advice to departments yet. I think Chair Wolf was gonna meet with some of our, I'll call them
Our regular visitors?
habitual.
Frequent flyers?
Yeah. So we'll wait and see how those meetings go and sort of keep it as an ongoing discussion. How about that?
Yeah, I'm gonna try that process out and see how it goes.
Yeah.
Next item on the list is communication policy. There was informal communication policies I developed with former Chair Washburn, that any communications provided would be listed in the administrator's report and provided to the members via the administrator's report, unless there was an urgent need for it to be emailed directly to the members at that immediately. It was I believe it was the consensus of the majority of the members at that time that they did not want to be continuously barraged by individual emails and so forth, and they wanted me to consolidate it and give it to them at one time.
Yeah, I'm familiar with this situation.
Yeah. That sounds good.
Okay.
And then, of course, there's always exceptions for items of urgency and so forth. But those issues usually go to the chair of the committees or the task force.
Yeah, my suggestion has been, in all years that I've been involved in this, is for every member to create a brand new email account that is specifically for this purpose, that has no connection with any other work or personal stuff that you do. And that way you can manage all communications that come and go through it without it kind of interrupting your workplace or interrupting your personal inbox or, other things like that. And then you can, dispense with those communications as need be. You could have everything filtered and forwarded to Victor and then
we got
that kind of thing. So, okay.
Preaching choir.
Okay, cool.
I believe we're down to the last two. How do we treat Ethics Commission rulings that disagree with decisions of the task force? And in this one, it goes a little bit beyond that.
We don't. They made their decision. We made a recommendation. They made their decision. Move on.
In addition to that, it's a matter of different versions of the task force disagreeing. I would bring to case the 150-word summary. There has been versions of the task force who has stated it must be in the body of the minutes. There have been versions of stated putting it in the addendum is fine. And then there's the decision of the Ethics Commission. So we have differing. The issue that I'm getting is from the departments. They're saying that they told me it was okay once. They told me it wasn't okay a second time. And then this person said it was fine. So who do we go along with? The decisions keep changing over time for them.
Right.
And so they don't know which direction to go.
So I was part of the task force that helped create the bylaw, the procedures for the Ethics Commission for orders of determination that were sent by the Sunshine Task Force.
Oh, right.
And we spent many months in joint meetings with the Ethics Commission on this. And the ordinance is very clear that orders that come from the task force are to be enforced by the Ethics Commission, which means they get an order of determination, the violation is there. All they need to do is figure out what penalty, if any, there is for that violation. But instead, they have amended that procedure so that they can re-adjudicate the entire case. And that subverts the work that this body does. This body makes the determination. If a member of the public wants to go directly to the Ethics Commission, there's that option. They can do that. They can bypass the Sunshine Ordinance Task Force, and then they have a different procedure. The Ethics Commission has a different procedure for dealing with that. But I think for the purposes of the rulings that we do, they need to recognize that the ordinance is very clear. I don't think the city attorney would refute it. And I think that it needs to be kind of dealt with.
What about the second situation where different versions of the task force over multiple years have ruled in different directions, opposing itself at certain times?
Well, that's why the president's log is really important.
Yeah, that's
and citing previous, like our own case law, is really important. So
I believe that would be an issue we'll eventually have to address more fully.
I think for some of those issues where it's been kind of all over the place, I think that those issues need to come to the task force and they need to make a decision on it in general. As like this is, like on the 150-word inclusion, that the task force definitively finds that and make that like a solid rule. That's like their solid precedent. And then in the future, if the full task force decides that's not feasible anymore because the world has changed, then they can discuss it but not over a case.
Just on the subject matter.
It would be just on the subject matter itself, and just say this is what we consider as precedent. And this is that way communication can be given to the entire city, and this entire city can move together and come into compliance, and it'd be very regular, ordinary, and normalized. So it's
Understand. That's something we can
Look into.
integrate into the precedence issue.
right. And I would say let's start looking at those really, those kind of very, kind of contradictory
I believe something like that will be HIPAA issues and
right,
things like that.
right, exactly.
And police commission issues. That's when that type of issue usually
Right,
comes up.
because we're going to start, I bet you anytime we're going to start getting wearable body cameras.
Yeah.
We're going to start getting cases about body cameras because
Yes.
they've already been determined to be public information.
Yep.
Then the question is when are they supposed to be released? And that's all over the courts now, so.
Can we get back to where are we on this list, though?
I believe that completes our list. If there's anything else you would like to discuss, it's open.
You want to take public comment at this time?
I just want to ask about the first bullet since I wasn't here. What was your
I believe there was
discussion about that?
we did have discussion. There was disagreement in that certain members believe that our current procedure is working and acceptable, and there was discussion that increasing the membership up to 5 was I hate to say a waste of resources, but was probably not a good idea.
Well, it would add to burden for folks then on the time of.
Yes, but there's basically disagreement for changing from our current policy.
Okay.
And I will note that in the minutes and in my write-up that I sent to the full task force. If there's no other issues, would you like to take public comment?
Minutes, that's it? Kidding. Wow. I'm at my wit's end with this. Dealing with the Arts Commission is a nightmare. Nothing has changed in 4.5 years. I get bombarded with annoying emails from Kate Patterson. A lot of them repetitive, but why? I don't.
Public comment on this item.
Which item? Your suggestions?
Yes.
You have no suggestions as to how to deal with repetitive respondents for basically the same thing. Late IDRs, documents not received, an abundance of paperwork that is just a waste of resources, trees, printing it out, dealing with it, trying to keep track. It's the same thing over and over again. And to put these 6 or 8 of the same complaints on different matters on one night causes me to spend an untold amount of hours trying to keep track of the repetitive emails and what does it relate to, and did I get the documents that I asked for in a timely fashion. And in every single incident, and this has been 4 years, I have not received the documents. I recently won a case at the California Court of Appeal. It was against a commissioner at the Arts Commission who was never even sworn in, never took the oath of office, not on file with the county clerk. She wasn't even entitled to the services of the city and county. No evidence. It was a malicious filing, and it follows a pattern of behavior that's gone on for many, many years. I don't even know this woman, basically. So I went to an executive meeting at the War Memorial of the Arts Commission yesterday. It was agendized for 12:30. I had not been in that building for a year and a half. I was there in the room at 12:30. At 1:15, they were still fumbling with the audio to try and set it up. They had a quorum. There was no reason for the meeting not to begin. They didn't address me. They didn't even make eye contact. And as I was waiting around for them to get their audio together, I just made a couple comments that I had violated the executive committee repeatedly for this issue and many other procedural issues, and it's now 4 years later, and they still haven't gotten their act together. And it's very frustrating and time-consuming on my part. I feel like I'm their mother or their police or something, and I really don't feel that that's my role. Many of the complaints that I file, Kay Patterson will come in trying to submit documents at the last second. They're never referred to subcommittee at all, and it's the same thing over and over again. I just am at my wit's end with this.
That completes public comment.
All right, let's call.
I just wanted to ask, I assume that we're going to send this, actually this is of Chair Wolf. Would you like to schedule this on the November 2nd meeting of the full task force or the December meeting?
I haven't finished reviewing the November agenda. Well, no, I have the November. I haven't seen the December agenda.
I haven't said anything.
That
will probably be relatively large.
The which one?
The December will have all the, I'm not absolutely sure yet, but the items heard by the committees in November will probably end up on the December agenda for the.
Okay. So why don't we maybe split it up a little? Let's bring a few of these forward and have a few of them at each meeting. And let's prioritize which ones are needing to be need some decision on them right away.
That'll work. I can work with you.
You want to do that?
Work with
I can schedule this on the agenda for the November meeting, and I will work with Chair Hinsey on a write-up from this meeting.
Okay.
However, it may not make it into the packet as the time is short.
Okay.
And I don't believe any action is needed on this item, as it's just a matter of writing a summary of the discussion and recommendations from this committee and sending it to the full task force.
Correct.
All right, would you please call item 3?
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Any public comment?
There are no members of the public in the room at this time.
Probably when she should have commented.
Item number 4, announcements, comments, questions, and future agenda items by members of the Rules Committee.
All right, any announcements, comments, or questions?
Nope.
No, all right.
Just a question. Are you feeling a need to have another meeting in the future? And when would you, anything is needed?
As
Okay.
needed.
Okay.
And this is,
We may need to have another meeting, depending, I think, on what the task force does with some of our.
and just for Chair Wolf, it's been past practice of the Rules Committee to send their minutes before the full task force for approval, as there's such a large gap between the Rules Committee meetings.
Okay.
That just wanted to be sure you're okay with that.
That's fine. Absolutely.
Would someone like to make a motion to adjourn?
So moved.
Second?
All right.
The meeting is adjourned.